Well, so this afternoon, let's take you to Parliament. The Majority Leader, Osei Mensa Bonsu, is asking the Speaker to reject the motion of rescission filed by the Minority Chief Whip, Muntaka Mubarak, challenging the Speaker's decision to refer 3 NPP MPs to the Privileges Committee. He says the move by Muntaka is not grounded in law. He also believes it will be a Herculean task for the NDC to convince the Supreme Court as well that the e-levy was approved on dubious grounds. This came up at a press conference held by the majority this afternoon. The parliamentary correspondent for us, Parker Wilson, has been monitoring the situation and now comes through with this report.
The majority leader, Osei Mensa Bonsu, is not too happy with some moves made by his colleagues on the other side, particularly the minority chief, Muntaka Mubarak. He believes that the motion of rescission filed by the minority chief whip is not grounded in law.
I think it's important to express disagreement with the chief whip for the minority in his own understanding of what the rules provide. A speaker can receive petitions from outside. And indeed, as you are all aware, demonstrators come to Parliament to present petitions. Who do they submit the petitions to, or do they intend to submit the petitions to? To the Speaker. And because the Speaker would ordinarily be presiding, he would oftentimes send the majority leader and the minority leader to go and receive the petitions on his behalf and submit the petitions to him. Once we receive the petitions, we relay same to the Speaker without any personal comments. Usually we will say to them that, well, the petitioning the Speaker will submit the petition to the Speaker. We can only assure that the appropriate steps will be taken to deal with the contents of the petition that you are submitting. When the Speaker receives such a petition, the Speaker is, within his remit, after perusing the document, to refer same to the appropriate committee for further investigation. So when my colleague said that he disagrees that the Speaker cannot receive petitions, I was wondering where he was deriving his strength from. Because clearly, by practice, by convention, speakers everywhere in the world receive petitions. And when they so receive petitions, they channel them to the appropriate committees in Parliament.
He also raised concerns about the attempt to injunct the commencement of the implementation of the e-levy. His view is that the president has already assented to it and that it will be an exercise in futility if the minority attempts to injunct the levy. Well,
I'll just say that the burden of proof lies on the minority to go to court and prove their case. The Supreme Court, I'm sure, no Supreme Court anywhere, indulges in processes and procedures relating to Parliament. That is their matter. Let them take it to court to litigate. But I believe that it will be a Herculean task on their part to convince and persuade whoever. They say they want to stop the implementation. But the bill is already being implemented. I don't know what they mean by that. Upon the assent of the president, a bill, if Parliament has not postponed the operation of the bill, immediately after the assent, it comes into operation. So if you fall foul to it, you can be prosecuted for falling foul to a bill that has been assented by the president. I don't want to pronounce on it, but I guess you and I would know that it's going to be an exercise in futility.
He's also been responding to the concerns about whether or not Joseph Osei should be in the first deputy speaker, and also the chairman of the Privileges Committee has the locus and the right to preside over the sitting that will give hearing to the 3 NPP MPs who have been directed to appear before them and answer some questions over their absence in Parliament.
Now, I see a challenge in that matter because the first deputy speaker is named by the orders to chair the committee. So if you are insisting that the first deputy speaker shouldn't chair, are you going to amend the standing orders to accommodate another person to be the chair? That's point number one. Point number two, if any member is conflicted, maybe so he has some interest in the business that is referred to a committee, that person can opt out to say that, no, this matter has come before us. I have a personal interest, so I'm opting out. But once he does that, it is for the caucus to replace him. And that's the rule. So unless maybe you don't know about that, if you say that...
The minority is yet to respond to the claims being made by the majority leader. For Joy News, I am Chrissy Parker Wilson.
Well, so Parker Wilson giving us the very latest from Parliament. We're set to get a reaction coming through from minority on this matter, who are equally challenging the claims. But first, let's hear from Parliamentary Monitoring Group, ODICRO. Nehemiah Tiga is co-founder of that group. They were present at that press conference as well. So I'm sure that by now, Nehemiah, you've been assessing the claims by the majority leader. Let's start off on the issue of the conduct of MPs, issues of absenteeism. Having heard the majority leader on the matter, do you feel that indeed the Speaker needs to rescind his decision on referring these 3 MPs to the Privileges Committee?
I mean, the Speaker does not need to rescind his decision. And think about it, he receives petitions. And when you receive a petition, you have to take action. There has never been an occasion where an MP in breach of Article 97 Clause 1C have been summoned before the Privileges Committee of Parliament to explain their chronic absenteeism, without written permission to the Speaker, or even asked to vacate their seats as the Constitution recommends. And so, if obviously if they fail to provide any plausible reasons. Now, this lack of action has set a certain precedence and has more or less encouraged a certain level of impunity among members of Parliament, or some members of Parliament. So if this action has been taken, this action is one of the best actions. And so I don't think the Speaker should rescind the decision in any way. This should go ahead. The committee should make. In fact, we would wish that the committee sits in publicly for everybody to see how they carry out their inquiries, and that will actually help our democratic dispensation or participatory democracy to a large extent.
I guess the concern of Muntaka Mubarak was about the approach of the Speaker. Is it not justified in making that demand of challenging the decision of the Speaker to refer these 3 MPs based on what he claims is a public petition and not from in-house, not from within the chamber itself?
So if the public are allowed to petition the Speaker or petition Parliament through the Speaker, then the Speaker should be able to refer petitions to the appropriate committees as their standing orders recommend, or as the Constitution recommends. So the Speaker is right in his action, 100% right.
Indeed, Nehemiah, there are more issues to, of course, deal with. Let's also bring in Roxanne Nelson Apiamakwa, who's the South Dangan MP and also a member of the Legal Committee in Parliament. So, first of all, you've been listening to the justifications by the majority leader on 2 critical issues. The e-levy as well has come up. The majority leader says, looking at what's happening in court, he does not believe that your side will be able to sustain your grounds, the grounds for which the e-levy should not be implemented on May 1. What's your take on that? Roxanne Nelson Apiamakwa, if you can ask, hear me. Yes, right. Yes, go ahead, sir.
First of all, let me say good afternoon to your listeners. We are on FM, right? Hello?
Yes. We're on the polls, yes. So, Joy News, yes.
Okay. Now, secondly, it's not correct that the bill having been assented to by the president has become law. The executive itself has suspended the implementation of the law and deferred it to a future date, which is first day of May. And let me give you other instances. you recall the passage of the Right to Information Act. Parliament passed the law, but the executive decided to defer the implementation with a provision in the law by Parliament. So it took the executive a whole year to implement that law. You recall the fact that we have the Road Fund Act in operation, but the executive has given an order to suspend the implementation of an aspect of the law, which is the tolling of our roads. So it is not correct that as soon as a law is passed by Parliament, it cannot be suspended. Its implementation cannot be suspended by the executive nor by the legislature or by the judiciary. What we are saying is that the president has assented to the law. It's become a law, properly so called. Its implementation has been deferred by the executive itself. And so, to that extent, we are asking the judiciary to defer the implementation further until the matter before it in respect of the constitutionality of the procedures leading to its passage into law is determined. How is this
question on that? Just a brief question on that. As it stands now, is the e-levy law or still at the consideration stage?
The e-levy is no law. It's not being implemented.
It's not law or it's not being implemented? Give us clarity to that.
It's law.
It is law, so it must be enforced, I guess.
Hold on. Technically speaking, but it is not implemented. Implementation of the law is what makes it law. When the law is suspended, it is no law, properly so called. So, for instance, today, if I engage in electronic transfer, I am not taxed pursuant to the terms and the tenor of the law.
Okay, then. We'll see.
You understand my point?
Yeah, I get your point. So we'll see how that would definitely pan out in court. But the concern as well has been about.
So I was rather hoping that the majority leader wouldn't have commented on the matter.
Okay, anyway, obviously these are matters that will be decided by the court. So
I would have said that we will leave that in the hands of the Supreme Court to determine on the 4th of May.
Precisely. But your colleagues as well, their conducting on the floor with regard to attendance has also come up. He believes that your minority Chief Whip, Muntaka Mubarak, is seeking to challenge the Speaker, his decision to refer 3 NPP MPs to the Privileges Committee. You believe that the majority is justified in what they are asking the Speaker to do, to rescind that decision that Muntaka has petitioned for?
I am the first that has said, indeed on your channel, that my minority Chief Whip got it wrong. The Speaker got everything right in law, in terms of procedure and the substantive law. Indeed, the Speaker proceeded under Order 53, Sub-1, Sub-D, or so, I think so, by way of statement to the House. The Speaker didn't say that because he received a petition from some person from outside, he was proceeding to refer the matter to the appropriate committee. No. He said the matters have come to his knowledge and attention. Okay, by petition and other means. You know, there have been publications on this matter. People have written extensively on their absenteeism and brought the details to light. So
Muntaka may not be right in his challenge against the Speaker.
But my Chief Whip got it wrong. He's wrong in terms of the procedure, in terms of the law. The Speaker has the right to make a statement to the House, and pursuant to making that statement, refer any matter arising out of that statement in the House to the appropriate committee.
Okay then. Roxanne Nelson Dapiamako, thank you. But Nehemiah, you are still with us. Also help us with this. What's the procedure and in terms of the standing orders? Where do we go from here? Are we expecting that once Parliament returns to its businesses, Parliament, the Speaker, and all of its organs will be triggered to hear this particular case involving the 3 NPP MPs?
Okay, so once the Speaker has referred the issue to the Privileges Committee, they would have to sit on it and also go through the process of inquiring from these MPs to get any form of reasons why they have absented themselves over that period of that over 15 number of sittings without permission, and then they would submit their report, and which would so there's some argument that should it be discussed or should it be voted on at the plenary. Again, I would say that no, because these folks never made any effort to trigger that motion to refer any of their colleagues to the Privileges Committee until the Speaker said so. So at this point, the only thing that's going to happen is going to go through that committee of inquiry by the Privileges Committee, and then they will submit their report. Hopefully, we would see something different happen where we get to the point where punitive measures, to the point of what the Constitution recommends, where people would end up vacating their seats for by-elections to take place, or for those who are ready and willing to represent their constituents to do so. You can look at various factors. For instance, Henry Kote is an MP minister, so it could be that the issue where we think that Article 78 then makes the president appoint these folks who are MPs, ministers, and then they end up doing double jobs, and that affects their job as MPs come under the spotlight. We can also look at a situation where maybe legitimately Adjoa Safo may have absented herself for medical reasons. By the end of the day, whatever it is, the rules say that you have to be absent with permission. We find ourselves in a place where we have the opportunity to reform our parliament, and that's what should happen. And I think the Speaker has that opportunity to do so. So some of his decisions may look out of place, but actually once he has the power and once he's aligned to the law and the rules of the House, I think we should support him to transform and reform our parliament.
What's interesting is that we have the majority sustaining this. The resultant effect is that we may lose 3 NPP MPs from the majority side. That would definitely affect their business going forward and make things tougher for them, because we're not guaranteed of the outcome of the by-election should it happen. Don't you think that the majority should be concerned about that as well?
Well, I mean, the majority understands they may also get in 3 MPs. If a by-election was to take place, maybe they also get 3 new MPs who would be efficient at doing their work, who would ensure that they follow the rules of the House as well. So the uncertainty and the unknown, we can't say anything about. But truth is, you would expect that, yes, the majority will be concerned about that. But at the same time, they also understand that even when the people are members of parliament, maybe their absent or being truant affects their output as a caucus or as a majority. So in effect, whether you are there or not, you do not add any value to their side. So maybe if they were to get in people who would actually support their work by making sure that they are present, or even if they're absent with permission, then that's a way to go for them. So you can look at it in different ways, depending on which side you sit on.
All right then, I'm grateful that you've been able to spend some time with us. Nehemiah Atigan, co-founder of Parliamentary Monitoring Group.